this.
Does it then act as a presumption?
It's an irrebuttable presumption, Your Honor, is our view. Because they clearly were not housing detainees for a 3-year period.
CoreCivic believed it could reopen a detention facility without a new permit. The city believed the law said otherwise. After 3 silent years, the empty prison became the center of a legal fight. Police claimed past operations blocked crime investigations. Officials warned the harm could not be measured in money. CoreCivic expected a routine path forward. Instead, the court questioned whether the company had already lost its rights forever. Now everything turns on one idea: irreparable harm. And one decision that could end the case before it truly begins. You're about to see the exact moment the legal ground shifts beneath them.
CoreCivic initially applied for a special use permit, and then it withdrew that application midstream, taking the position that it no longer needed one, even though the zoning regulation required at that point a special use permit to operate a jail or prison within the city.
The argument begins with a simple claim: the law allows courts to act before damage is done. This isn't about punishment yet. It's about preventing a risk the city believes cannot be undone.
KSA 12-761 explicitly authorizes injunctive relief under these circumstances even before a violation has occurred, when there's a threatened violation. That's what we were dealing with here, and that was the basis for the district court's injunction.
You still have to prove irreparable harm, correct? Or
When
approximation of it.
One could debate that, I think, under 12-761, but I'll answer the question. The city did.
All right.
The city
Tell
did.
me how.
There were 2 affidavits that the city submitted. One was from the police chief outlining how, when CoreCivic was operating this facility 3 years before, it had been vacant for 3 years, they were unable to investigate crimes.
Allegations about crime scenes and blocked investigations shift this case from zoning rules to human consequences. Suddenly, the courtroom is no longer debating paperwork. It is confronting the possibility of lost justice.
They were thwarted in their attempts to investigate crimes. CoreCivic was at times having inmates clean up crime scenes before the police could get there to investigate them. They were interfering with the police's ability to interview witnesses. And then we also had an affidavit from the supervisor of the wastewater division about the problems that CoreCivic was causing downstream because they didn't have a grinder pump. A grinder pump's basically a garbage disposal on steroids. And if something solid goes into your sewage system, it grinds it up so that they can then be processed. So
these are all major concerns for land use.
They're very major concerns for land use. And to get to the nub of the problem, CoreCivic provided no evidence, through affidavit or otherwise, that it had done anything or was going to do anything to keep those problems from happening again.
It didn't seem that the trial court elaborated much on this.
I don't believe the order elaborated on it very deeply, but the court can obviously affirm the decision if there's evidence in the record to support it, irrespective of whether the trial court specifically called that out in the order.
Counsel made an assertion that past harms cannot constitute irreparable harm. So what you just cited, does that rub up against what you just cited as your basis for irreparable harm?
I think it does support that because, like I said, if CoreCivic had come in with affidavits, here are the things that we've done to keep these problems from happening again. We've bought a grinder pump. We've put it in during this time it's been vacant. We can promise you're not going to have those problems again.
With no evidence of fixes or safeguards, the silence from CoreCivic becomes part of the argument itself. In court, what isn't proven can matter just as much as what is.
This would have been a tougher case for us, but they provided no evidence whatsoever to respond to that.
Are those, what you just cited, are those issues that go to irreparable harm, or are they kind of meritorious bases for why it was reasonable to rescind the permit?
A little bit of both.
So does that overlap, or are those separate?
It could overlap because and this gets to the question, how far can you go on a 12-761 injunction? You have to show irreparable harm. Our position is if you're dealing with the zoning violation and you continue to tolerate even de minimis violations, eventually at some point you have a big problem. So maybe irreparable harm would be relaxed there, but here we actually proved it through the evidence that we provided.
Counsel, I'm intrigued by this idea. The way I read this record is they never have had a permit. They've never had a special use permit. It was grandfathered in to begin with. And then they quit using it as a facility,
Right.
even though it's still there. So do you re-grandfather something in once you
No.
quit using it? What does the law say on that?
Well, the way the development regulations, which is the zoning ordinance, reads, effectively, they were deemed to have a special use permit when they were grandfathered, even though they didn't have the piece of paper
By the ordinance or administratively by the city?
by the ordinance. They were grandfathered
All
in,
right.
so they're deemed to have a permit whether they actually have one or not. That is then what allows the city commission to administratively rescind that after they stopped using it as a detention facility for more than 12 months. And it was actually for 3 years.
3 unused years may sound simple. But in zoning law, time can erase rights completely. The question now is whether absence alone can close a prison forever.
They stopped using it in that manner in very end of 21, 22, beginning of 22, after the Biden administration issued an executive order prohibiting the Department of Justice from contracting with private prison operators. And what's significant here is the not putting more people in there after that was a choice, because the executive order only applied to DOJ. They could have gone and contracted with ICE. There was nothing to stop them from doing that. They could have contracted with the state of Kansas to operate this as a minimum or medium security facility. There were a lot of things they could have done with this property. Instead, they let it sit vacant, and all they did basically was keep the lights on.
The second item that strikes me in this is a temporary injunction.
Yes.
Where is this lawsuit going from here?
Well, follow up.
Depending on how we rule, of course, I
Well,
understand it.
we're now going outside the record, but I think it's out there in the public domain. CoreCivic has applied for a permit, and they're scheduled. They had planning commission hearing last week, I believe. Planning commission recommended approval. City commission takes it up now. The final hearing is March 10. And our feeling is if the city commission issues that permit, this case becomes moot. So that's, to answer your question, that's where this is going.
Thank you, Counsel, because I thought maybe that might be what your
Right.
answer was,
And-
but I wanted to hear it.
And if the city commission denies that permit, there may be another lawsuit on a different basis challenging it under Golden.
Well,
Yes.
we're open year round.
Unfortunately, we are too.
Counsel, in light of that procedural posture and the fact that there are these other administrative proceedings going on, we don't tend to issue rulings and opinions just because we find issues interesting,
No.
right? There has to be a concrete matter before us. It feels like we're in a strange position here.
I thought about that a little.
Even the judges sense uncertainty. If a future permit could end the dispute, the entire fight might disappear overnight. Yet for now, the conflict remains very real.
I don't think the case is moot at this particular moment because they don't have a permit. But if they get a permit on March 10, it does become moot. So
Counsel asserted that they would still have a money damage claim. But do you have a response to that?
well, I think they would have effectively mooted it at that point, and they've not. I'd have to go back and look at their petition, or actually, they've not counterclaimed for damages.
There are damages for, I guess, the improper granting of the temporary injunction.
Right, which would require this court to reverse that temporary injunction because that's the only basis upon which there could be a wrongful injunction claim.
Which is why they're saying it wouldn't be moot.
Yeah, I suppose that might be an argument, but right now we're just here on temporary injunction, and we believe we proved the necessity for one. One point I wanted to make too on the irreparable harm is that and we touched on this in the brief, is the inadequacy of legal remedy.
Some harms cannot be counted, priced, or repaired. The city argues this is one of them, where delayed justice becomes permanent loss. That idea sits at the heart of the injunction.
Because I don't know how you calculate damages based on the police inability to investigate crimes. There are people who get hurt by that. There are victims in the facility who are hurt by that. And that is prototypically the sort of thing that you can't even bring an expert in and quantify. And it's the inadequacy of legal remedy that creates irreparable harm. We touched on this in the brief that maybe the 5 factors from Harper really ought to be 4, because irreparable harm is the inability to calculate damages. And that's what we have here. It's simply something that can't be calculated. And that's why there was irreparable harm. We also made the point, as actually in our motion, that once detainees got into this facility, it would be much more difficult for the city to do anything about that. Because it would require a state court judge telling CoreCivic, you've got to move people out. And their position has been, well, once ICE tells us that somebody's in, we don't have any control over where they go. And I think that concern has been somewhat prescient because, as we've seen, even federal judges have had difficulty getting ICE detainees out. So you can imagine the difficulty that a state court judge would have in telling a contractor to move people out when you now have the federal government in there with a concrete interest. So that was another reason why temporary injunction was appropriate here. When I want to shift over to the success on the merits, because the basis that the district court largely relied upon was the fact that CoreCivic had not filed a timely 12-760 suit challenging the legality or the reasonableness of the city commission's resolution. That resolution was adopted on March 25. It was delivered to CoreCivic a couple days later. And by the time of the hearing, which was June 4, they still had not filed anything. And that was what the district court really hung its hat on. But that was an appropriate thing for the district court to do for the reasons we cited in the brief. The district court, when you're faced with a temporary injunction, you're having to predict how this case is going to turn out when you're assessing likelihood of success on the merits. This was not an affirmative defense. Rather, this would have been an affirmative defense the city would raise to a hypothetical claim that CoreCivic hadn't even brought yet.
The parties have alluded to the fact that there is a separate lawsuit ongoing on that issue. Is that accurate?
It's been filed, but not prosecuted. It's not been, to my knowledge, I don't even think the city's been served on that one.
This is a difficult case because it feels like there are all of these slippery parts that are not part of the matter before us. There's a separate lawsuit. There are ongoing administrative proceedings.
CoreCivic filed, CoreCivic filed a suit in federal court.
Multiple lawsuits, multiple courts, and conflicting strategies reveal how high the stakes truly are. When legal battles spread this wide, resolution becomes harder and consequences grow heavier.
Federal court seeking injunctive relief based on some supremacy clause, and the district court there dismissed the suit, denied their preliminary injunction motion. So yes, this case has been active on a number of fronts over a relatively short period of time. But we're here today on this temporary injunction, which the district court said was warranted because of the fact they had not brought a timely challenge, raising a lot of the arguments they came in and raised. But I also believe that even if we get beyond that procedural reason, substantively, it was proper. The city would be likely to succeed on the merits because they needed to have a permit to operate. As we've alluded to, they vacated the space, at least as far as detainees are concerned, for 3 years. And it sat there. They kept the lights on, they kept the floors mopped and so forth.
As I read the development code, there's a discussion about legally non-conforming or a non-conforming legal use and a special use.
Right.
That code provision doesn't say that that is an implied special use permit. It seems as though we're discussing it as though it is. And then there's a separate code provision that talks about rescinding a special use permit. Can you help me with the logical jump between those two provisions?
Sure, I think those are separate. The first thing you were talking about, Your Honor, is in response to one of Judge Hill's questions, they were deemed to have a special use permit because of the grandfather part of the development regulations. Because we can't come in and
Now, and the statute doesn't, or the ordinance doesn't specifically say that, but we just make that logical leap.
I think it effectively it says you're treated as if you have a special use permit. It may not have that exact language, but that's the position. And I think the word deemed might even be in there. I don't recall off the top of my head, but that was the point we made. But then if they stop using it in the manner that would ordinarily require a special use permit, which is holding people, and that continues for 12 months, the city commission can administratively rescind that special use permit, which they're deemed to have. There's a separate provision on non-conforming uses that says if you stop your non-conforming use for 24 months, it can be terminated. So there are really three things scattered around the code, but that's how they play with one another. Now, I want to touch very briefly on this abandonment argument, though, because their position is, even though they may not have had detainees in there for 12 months, 3 years actually, we still had to prove an intent to abandon. And that really doesn't make sense. We cited a bunch of cases, Kansas and other states, where if you have this temporal limit on non-use, you no longer have to prove intent to abandon. And there's a reason. It creates a bright line test. And here's the point I really want to leave with on this. If you have a temporal limit like that and you still have to find an intent to abandon, the temporal limits become meaningless. Why have a temporal limitation if the person could come in and say, oh no, I never intended to abandon that? That really violates accepted canons of statutory construction because you're making that temporal limitation meaningless in the context of the facts of a case like this.
The closing claim is absolute. 3 empty years ended the right to operate. If the judges agree, the story ends here without a single detainee returning.
Case like this.
Does it then act as a presumption?
It's an irrebuttable presumption, Your Honor, is our view. Because they clearly were not housing detainees for a 3-year period. And that's the housing of detainees that triggers the permit requirement.
The court did not decide guilt or innocence here. It decided whether the risk of harm was too great to ignore. A silent building. 3 missing years. An illegal question that could shut the doors for good. Was the city protecting the public? Or stopping something that still had a legal right to exist? Tell us what you think justice required in this moment.